morning to all of you. In the context of India's 75th year of independence, there has been a nationwide celebration. Far from having some rituals, there are also meaningful talks as to the content of India's independence. And today's topic, Indian judiciary's responsibility in defending the Indian Constitution. A very important topic because of the several organs that has been created under the Indian Constitution. There have been powers have been given to respective organs of state. Now each organ of the state has a well-defined power. But if you consider the power given to the judiciary, is the most important power that has been given. You have seen games, IPL, several sports. Every game has a sports person to see whether every sport is also having certain rules of game. To see whether the rules have been followed, you have an umpire. So normally, judiciary is always considered as an umpire between the players, namely the bureaucracy, the legislature, the uniform forces, whether they play the actual role assigned to them. The judiciary sits as an umpire. But unlike a role of an umpire, suppose you believe, instead of judging the players, the umpire himself starts playing. That is most dangerous. That is why there has been a definition of powers between the state, within the organs of the state, namely the legislature, the government, and the court. Now there is a famous doctrine, Montesquieu doctrine, is an American jurist. He said that each organ of the state has to play a assigned role. They cannot cross the border. In fact, I always used to say, if one organ of the state crosses the border, it becomes the cross-border terrorism. I will use a very strong word because there has always been a conflict as to who should exercise what power. We always think there are two houses of parliament. Now people say that the judiciary cannot become a third house of the parliament. They cannot legislate. On the contrary, if you see the scheme of the Indian Constitution, the Supreme Court of India is one of the most powerful institutions in the world. That unlike other countries in the world, that we have the most powerful judicial institution in this world, in this country, and therefore, all the more reason that the judiciary's role or responsibility in defending the Constitution is important. In 1976, by the 42nd Amendment, a new provision was introduced in the Constitution, Article 51A, which for the first time gave the citizen certain fundamental duties. Now there are fundamental rights, now there are fundamental duties have come. Now always they say the rights cannot by itself is a virtue. It has to go along with the duties. Whatever the statement, a non-performance of a duty, there is no penalty under the Constitution. But if you see the fundamental duty, there is not even a single provision which says the citizen has to respect the Constitution. If you see the Bangladesh Constitution, Article 7A of the Bangladesh Constitution, we also helped them drafting that Constitution. But one specific provision was brought in. If anybody denigrates, anybody disobeys, anybody subverts the Bangladesh Constitution, he is liable for prosecution, and the penalty is the maximum prescribed under the CRPC, the Code of Criminal Procedure. Now you know the Criminal Procedure Code is almost common in the subcontinent. Therefore, what we have, the similar code, they are also having. The highest punishment is the death penalty. There is no other country in the world which says, if you disobey the Constitution, if you denigrate the Constitution, you will have a death penalty. But we did not have, because we think, and we also do believe, that we have a fundamental right to criticize, fundamental right of expression. Article 19, 1A guarantees to all in this country a right of expression. And therefore, even the Constitution is not considered as a scripture, as a holy book. It has been amended more than 100 times, depending on the wishes of the people. Therefore, when the Supreme Court of India, and to some extent the high courts of various states, have a power specifically conferred to see whether the laws passed by the parliament, orders passed by the government, are in conformity with the fundamental right chapter, they have a power of judicial review, which is the most potent power. And in that sense, the Supreme Court has an edge over the other organs of the state. An umpire is not a player, but an umpire has more power to decide who is the winner. It is in that sense, Article 13 of the Indian Constitution gives a specific power. If a law is made before the coming into operation of the Constitution of India, or a law which is made after the coming into force of the Constitution of India, it has to be in terms of the fundamental right chapter of the Constitution. That is, no law can deny you the right guaranteed under the Part 3 of the Constitution. Now, if you see the Part 4 has got several promises to the people. In fact, it is a socialist charter. On 26 November 1949, when the final draft of the Constitution was ready, Dr. B.R. Ambedkar, who was the architect of the Constitution, who was the chairman of the drafting committee, he spoke in the House, introducing the Constitution. In fact, one of the finest speech you can ever see. He makes several explanations. Finally, he tells the House members that this draft has been given to you, adopted by the members of the House. It is for you to work or destroy. We have received a political freedom in this country, but we are yet to have an economic freedom. We are yet to have a social freedom in this country. Political freedom is guaranteed because the British Union Jack was brought down. And then the tricolor flag has been raised in the ramparts of Red Fort with a very fine speech by Pandit Jawaharlal Nehru, who said, when the whole world isn't sleeping, India will be awake to get her freedom. Now we got the freedom. We have a draft constitution which defines. In fact, Justice Krishna here, I use very well known for coining new words. He called the constitution as a pachydermic parchment. Parchment is a paper. Pachydermic is an elephant. It's an elephant-sized paper, or a mother of all laws. He also said that this constitution, if it is not going to be worked in favor of the people, then the constitution has no meaning at all. It has to be worked. And how do you work? What is the vision of the constitution? What does the constitution talk about? If you see the directive principles of state policy under Part 4 of the constitution, it gives several promises to this country, a country which the majority of the people are underprivileged. It talks about there cannot be a monopoly over the resources. It has to be equitably distributed. No other country in the world has a constitution which has socialism inbuilt into this constitution. The watchword, unfortunately or fortunately, they say that the rights guaranteed under Part 4 cannot be specifically enforced except the Parliament has an obligation to bring law in terms of those promises. And therefore, whenever laws are brought in, the court with its own vigilant eyes sees whether these laws are in conformity with the fundamental right. Apparently, they try to create a conflict between Part 4 and Part 3. Instead of reading harmoniously, there is an apparent conflict. Now, the first test came to the Indian Constitution. I am emphasizing this issue because there is a jurist who said, it is not what is written in the Constitution, it is what the judges say. That is the Constitution. And therefore, there is a greater responsibility in the judiciary to say what the Constitution is all about. The first question, in fact, very strained, it was put on the Constitution, was in the very year in which the Constitution was enacted. There was a communal GO given by the then Madras government, which is part of, Malabar was part of the government. The communal GO provided jobs from 1920s on the basis of caste. There is a seat reserved for the Brahmins, seat reserved for the non-Brahmins, seat reserved for the Dalits, seats reserved for the Indian Christians and Muslims. It was purely a religious and caste-based arrangement, which is otherwise called a communal GO. The first question came when the Article 15 talks about no discrimination based on language, based on religion, based on caste, based on descent, based on area, or any one of them. Article 15 was a very crucial constitutional provision. You would have seen there was a film called Article 15. Somebody asked the director, why do you name it as Article 15? He said, among all the provisions, among 300 odd provisions in the Constitution, the heart and soul of the Indian Constitution is Article 15. Because it is the only article which says that the state shall not discriminate based on religion, based on caste, based on language, based on descent, based on area, or any one of them. Therefore, last 20 centuries, we had a different dispensation. Different kinds of rulers were there in India. Then the British came, they did not provide all this. For the first time, an elected government, a newly won freedom, gave the spirit to frame an article which said we shall not discriminate. Now the argument that was put before the Supreme Court was that if you say there can't be a discrimination based on caste, how is that you are having a communal GO based only on caste? The question was whether the newly enacted constitution satisfies the Article 13 test of communal GO, and the Supreme Court said that the communal GO is bad in law. The original idea of communal GO was that there should be equitable distribution of the resources of the state, namely the employment, educational opportunity. And therefore, it was acceptable that give it to every community some quota system. Good or bad, it has been there for several years. Now under the radar of the Constitution, this was found to be having a mischief of Article 15, Article 16, and therefore it was struck down. It led to various protests. The Constitution came in 50, and there was a huge protest in the same year saying that how did you take away the benefits we enjoyed? The Dalits would not have got any employment. The non-Brahmins would have been edged out. The Muslims and Christians would not have had a share in the total cake. And therefore, there was a protest also. Therefore, there was a demand of a social justice on the one side. On the other side, the constitutional radar saying no discrimination. Now there has to be certain harmony between what happened earlier and the new constitution. Now, the new cabinet which took over did not do what to do with this protest in the South India. At that time, the Madras presidency was the entire South India except the Travancore area. Now, when this protest came, the parliament awoke. Parliament said, all right, we will now amend the constitution. The first amendment came to the constitution, to Article 15 and 16, to provide that the state can make affirmative action in bringing equality. Article 14 talks about equality. Article 15 and 16 talk about non-discrimination. Now, to make a balance, they said an affirmative action to providing special facilities for socially and educationally backward people, we can make new provisions of reservation. That's how the reservation came as a constitutional substitute to the earlier provisions of communal GO. And the first constitutional amendment made a new test. The test was whether the constitution meant for the people or meant for certain academic exercise. Now in this process, we have now got more than 100 amendments have come. That is why I began by saying that it is not a holy scripture. It is not a religious text where nobody can touch. Constitution has to be alive. Constitution has to be organic. Constitution has to be dynamic to satisfy the needs of the people. In that context, the constitutional amendment passed the first muster. It passed the test that it can be amended. Now the amendment came and it stayed, and we have reservation today providing for affirmative action to the underprivileged sections of the people, SC, BCs. Now it has also gone beyond the point which you will be discussing in your constitutional law class, where now it is not social backwardness, it is not educational backwardness. Now there is an amendment providing for economic backwardness. This was not the original part of the Constitution. In fact, whether the Constitution's original part will prevail or the amendment will also take part of the another facet of the Constitution is a great debate. You have seen recently in the American Constitution, the abortion rights for the women. 50 years ago, the American Supreme Court ruled the woman has a right to have abortion. That was made as a right of a woman. Now that is a Roe versus Wade case. Now that case was overruled recently by the US Supreme Court by saying there is no such provision in the original text of the Constitution. Fortunately, we do not believe in that theory because we feel that the Constitution is a growing document and therefore we amend. We make amendments. But who is to decide whether these amendments satisfy the test of the Constitution or not? After several years of our constitutional experiment, a question came in 1969 when private banks were nationalized. Banks belonging to Tatas and Birlas and Singhanias and several other monopoly houses, they were also running a financial institution, making money, taking money from the people and using it their own private purpose. At that time, the Prime Minister of India, Mrs. Indira Gandhi, who said that we cannot allow these commercial banks to make profits out of the people's money. It should largely come to the public sector. So 14 banks were nationalized. The Nationalization Act was challenged by no less person than the Tata's house. You must have seen and read in the law books, Cooper versus Union of India. The Supreme Court applied one test, that whether the right to property is an illusory right or it has some substance. When the nationalization was made, what an amount of compensation was given to the private banks. There is nothing like a private because the banks were only using people's money for lending and borrowing purposes. They were paying interest. It is not anybody's private property. But still, the court ruled that this compensation given to the banks which were taken over was not enough, illusory. Therefore, the Nationalization Act was bad. That was a time, there was a test whether the parliament is supreme or the courts are supreme. It is not a question of superiority test. It's a question of defining powers. Who should have what powers? Can the court interfere with the socio-economic legislations which are brought for the ameliorating the problems of the people? Should he not? Article 39 talks about decentralization of properties or a public wealth. Concentration of wealth in few hands have been prohibited under the Constitution, but still the court ruled more in favor of a property right. If you see the debates in the parliament at that time, cutting across party lines, every member, whether it is a communist party or a Marxist party or a Congress party or anybody matter except those few people who does not represent the greater interest, the majority discussion said that the Supreme Court should not have that kind of power to deny and deprive a legislation which was brought for a socio-economic benefit. Then what do? You can't overrule a judgment because ultimately under Article 141, the decision given by the Supreme Court is binding. Under 142, the decision of the Supreme Court has to be enforced by the government. And when there is a constitutionally mandated responsibility, how do you get over this judgment? Fortunately, under law, you cannot overrule a judgment, but you can change the basis of the judgment. Therefore, an amendment was made to Article 31, saying that right to property may be there, but no court can deny a legislation only on the ground that the compensation offered was not sufficient. That is left to the government and not to the court. Now, when this amendment came, the 24th Amendment, it brought two issues to the focus, whether Supreme Court can strike down laws meant for welfare of the people, and whether the Parliament can overrule, change the basis of the judgment. Until such time, when a case came from Kerala, the Kerala Land Reforms Act was challenged by a Madadipati known as Kesavananda Bharati. Kesavananda Bharati challenged the power of the government, power of the Parliament to amend the Constitution itself. Now the question came whether the Constitution can be amended by the Parliament. If so, what is the width what is the length under which the parliament can amend. So the Kesavananda Bharati became a milestone in the Indian constitutional history. I would also say, to some extent, both ways it helped. The Supreme Court for the first time ruled that the constitution can be amended. Whether they can amend the fundamental right, they said that can also be amended. At the same time, the Supreme Court said or put a fetter that the basic structure of this country, of the constitution, cannot be amended. What is basic structure? Did they list out, these are all the basic structure? They did not list out. They only said preamble, then the judicial power of review, then the parliamentary system of democracy. Broadly, they laid down some guideline, but they did not lay down what is basic structure. Again, there is a catch, because ultimately, for every case, whether it amounts to basic structure or not, again will be left to the judiciary itself. In some way, the judiciary retained the power to become an arbitrator to decide whether a particular law is not taking away the basic structure of the Constitution. Now, this is very important, that this is not a game between the lawmakers and the judiciary. This is something like a vibrant democracy. But one good thing has happened. After 75 years of independence and 72 years of a constitution, we still look like an organic country where constitution grows, constitutional debate grows, and some of our judgments are being followed. Not only in our neighboring countries, even some of the far-off states also take a cue from these decisions made by the court. But what is today the most worrisome is that the 42nd Amendment to the Indian Constitution brought in two important segments. There are so many criticism of the 42nd Amendment because many of the opposition leaders were kept inside. The fundamental rights were suspended, and the court also unfortunately ruled that if there is a suspension of fundamental right, you can't come to court. The very notorious ADM Jabalpur case, which you would have read in the college, that you can't come to court. Then why are the courts are there? You can't come to court. One of the most powerful institutions denied itself the power to review, and the judgment for much later, even in Puttasami's, that Aadhaar card case, the Supreme Court said that judgment was a wrong judgment. In fact, some of the retired Supreme Court judges went on record by saying that is the most blackest judgment in the Indian judicial history. Now, having given that kind of a judgment, now what is that you are now trying to say? There is a preamble to the Indian Constitution. Under Kesavananda Bharati's case, it is also a basic structure of the Constitution, the preamble. Now, India is a socialist and a secular democracy. These two words have certain meaning to the Constitution itself. It was not there before, but then the ingredients of both were found in Part 4 of the Constitution and Part 3 of the Constitution. It talks about secularism. There is Article 25, 26 and Article 30, providing for right to minorities under Article 30. Now, it is in that sense, secularism has got a meaning and socialism has got a meaning. Now, for the first time, the very word itself came for ridiculous interpretation by the Supreme Court. When labor law was amended, there was a provision to take permission for closing industries. When this was a challenge, certain arguments were advanced on behalf of the working class and the government, saying that if it is a socialist country, the enterprise must be managed by the public sector. The public vigil must be there. A person cannot start an industry and run off. And therefore, there must be a social control, and socialist preamble must be kept in mind. And Supreme Court gave a very curious judgment, saying socialism is a catchword. This is not a word coming from some platform speakers. It comes from the mouth of the Supreme Court. In fact, once Krishna Iyer said, there may be one Supreme Court building in Delhi, but within that there are 34 Supreme Courts. What he meant was that each judge decide what is good for them and what is not good for them, or what is his understanding of the law. There is a wider debate. But in this Excelware judgment, Excelware was the Union of India, Supreme Court made a very startling proposition that socialism is a catchword. It means different thing to different people. Therefore, what is the reality is that India is not a socialist country. Nobody says it's a socialist country, but the aim was take it to the socialism. Come to secularism. What is secularism? a state treats all equal, all religions equal. Under Article 25, you have a right to preach, right to profess, right to follow any religion of your own choice. The choice is yours, not of the state. Now, when there is such a wide, now we have laws which says if you change the religion, then it can be prosecuted if you don't follow procedure. Now, all these laws are now under challenge, which are still pending. But what is important today is, what is the content or what is the meaning of the word secularism? Now, you have two different definitions. The state keeps away from all religion. It's very neutral. Or as they say in the Western countries, it is divorced from, state is divorced from religion. Therefore, state shall not fund religion. But in our country, we have a different definition. The state treat all religion with equal opportunity. All right, that's one way of looking at it. But what is most important today, somebody says, I belong to this doctrine. We belong to Hindutva, not religion. This is a philosophy. Now, fortunately or unfortunately, a bench of the Supreme Court says the word Hindutva is also part of secular concept. Now, the word secularism and socialism are an inevitable concept because subsequent to the 42nd Amendment, there has been an amendment to the People's Representation Act that any political party which wants to stand in election, they will have to amend their party constitution, affirming their faith in socialism and secularism. Now, even the BJP party has amended that. If you read, if you go to the website, you can see in socialism and secularism. We find all over India, there is an attempt to thrust the majoritarian concept of religious principles. Now, when some children come to the school, you stop them at the gate and say, your dress is not acceptable. Go away. Now, the Karnataka full bench says, no, it's valid because discipline. What has a uniform has got to do with discipline, we do not know. Suppose some girl wears a small kerchief kind of things on the top, calls it hijab, and you say it's indiscipline. I am only reminded of one thing. In our school days, many of the boys came without shirts. Only trousers they will be wearing. Still they were allowed in school. Still they passed out. Still they wrote examination. Now we find in Karnataka, there are 20,000 girls who are not allowed to write their 10th examination because they came not only with uniform, but they also came with their headscarf. Now the Karnataka full bench says, no, it's valid. We asked the Supreme Court, will you decide this matter? There is a future. There is a danger of these 20,000 girls being not able to go to higher education. The Rajinder Sachar committee says that the Muslim women have been put more backward. There's a necessity to give them a formal education. When the society has to be inclusive, bring people to the educational institution, this happened in our days. The teachers used to go to all parents' houses and say, please send the children, whether with or without clothes. Now they say it should be in a particular form. Does this rule of prescribing a uniform, does it conform with Article 21A? We are a country with plural faith. We are a country with a mosaic of all religion, several languages, several eating habits. In this context, will you say there will be one nation? Agreed, there will be one nation. But there will be one food, there will be one language, there will be one leader. Will you agree? Is it part of the constitutional right? Now, therefore, when these issues are raised, when Jammu and Kashmir, which has been given special status, only by an instrument of accession, it was made part of India, and it has been given a separate flag, it is the Prime Minister, Chief Minister is called Prime Minister, and the laws made by the Indian Parliament will not automatically apply to Jammu and Kashmir. These special status were considered important to bring the people to this part of India and not go away elsewhere. Now, Article 370 has certain meaning, certain content. Now that has been removed. Now we are only saying the removal of 370, whether it's part of the Constitution, review, when will you decide? 4 years have gone. There are amendments to the Citizenship Act. Whole lot of people have been made stateless. Whole lot of people have been made refugees in our own country. Refugees are always people who come from outside. This is the only country where people of India themselves have become refugees in this own country. And states like Assam are building huge prison houses for these people who are considered to be an alien, foreigner. within inverted commas. Now we are saying there are several state measures, let them do because they have been given mandate by the people. But ultimately as an arbiter, as an umpire, when will you decide these matters? You have time to go all over. In fact, the third senior judge went to London, the chief justice went to America, and 3 senior judges went to Russia during this vacation period to talk about several things on law. But in London, the London School of Economics students asked the judge who went from here, Mr. Jai Chandru, one of the brilliant judge, no doubt about this, about their capacity. But they asked the question, why is that the minorities have been treated so badly in your country? Very embarrassing question in a foreign country. But you must bound to answer. People want to know. We want to know. There used to be a politician, there used to be a TV anchor who say, we want to know. Already we also want to know. Now he is getting over the embarrassing position. He told the students, some of these cases are before me, I can't answer. So he recused himself from answering this question. Somebody else went to America, the Chief Justice of India. He said, India is ruled by the Constitution. All right, when will you give our judgments? Justice delayed is also justice denied. It is not mere corruption of taking money, cash for orders. It's beyond that. We want justice at time. We don't want our grandchildren to see. Today we have 4 crore cases pending all over India. In Tamil Nadu, we have 7 lakh cases in the Madras High Court. Now, when will you decide all these matters? Our grandchildren, our grandchildren's grandchildren. Therefore, we feel that the judiciary has a responsibility not only to uphold the Constitution, but also to quickly deliver matters where people know where do they stand. Is Kashmir bifurcation valid? Is Citizenship Amendment valid? People want to know. Even though you know this Sabarimala judgment, there is a constitutional bench has ruled 4:1. Women can go and worship. That's a judgment of the Supreme Court. And now some people doubt that. The individual opinion shaped into a collective pressure. There are private individual group which thrust their views on others. What is called as the majoritarian notion. Now this is put a pressure. Now the matter has gone to a 9-judge bench. All right. Even the entire Supreme Court should hear 34 judges. But when will you decide? Nobody questions the authority of the court deciding matters, but it should be done in a time frame. You know, the case of George Floyd was killed in public by the policeman. He's a black. The movement came all over the world. The black lives are matter. Every life is matter, but then the black lives are so treated badly. Now that judgment went to the Sessions Court, the District Court, then it went to the State Supreme Court, then it went to the US Supreme Court. All were over in 1.5 years' time. Now all the policemen are in jail. Now we need to have a judiciary which is vibrant, which is within time frame deliver judgment, which is also wedded to the Constitution and decide matters strictly in terms of the constitutional principle. It is in that context that the judiciary has a right, judiciary has an obligation, judiciary has a duty to protect and defend the Constitution of India. Nothing else. No, their personal views doesn't matter. Each judge may give some lecture outside in academies, in law colleges. But beyond that, when you sit in court, decide only on the basis of the Indian Constitution. No other text can guide you. Once Krishna Iyer said that people say the word committed judiciary. When some judges are superseded, people were accusing the government of bringing committed judiciary. He said committed judiciary is not a dirty word. What is the commitment that we are talking about is a commitment to the Constitution of India. That commitment is also a commitment. When you take the oath of office, you say, I shall uphold the Constitution of India without fear or favor, without ill will, we'll uphold the Constitution. Please uphold the Constitution. Nothing else. And therefore, in this 75th year of independence and the 72nd year of the Indian Constitution, we appeal to the judiciary, please defend this Constitution. Please defend the Constitution in its letter and spirit. Please defend the Constitution for the purpose for which it is enacted and continue to have in this subcontinent the only country which is having a constitutional democracy. In that way, students of law or students who have faith or people who have faith in the rule of law must think and must tell and must fight for a vibrant judiciary which will uphold all constitutional values. Somebody talked about constitutional morality. And last week there was a meeting in Madras where one retired Supreme Court judge, Chalameswar, said, they asked him what is constitutional morality. He said, there are words that are having cliches. It means different things to different people. That is a very cynical way of saying, I am saying a constitutional morality is that when you take the oath of office, please adhere to the oath of office. Thank you.